This is Learning Unit 3 for Professional Ethics, LJU 4802, and once again, please have your study guide with you because you need to follow me as I take you through Learning Unit 3. Learning Unit 3 now focuses on the South African legal profession as it is. Now you will see in a lot of previous papers, we always or like asking the fit and proper person test. That test, even though it was in the Attorneys Act and the Admission of Advocates Act, it is also part of the Legal Practice Act. This question can have different ways of asking it. And if it is 30 marks, you have to give me everything. You have to start by saying that this fit and proper person test is a discretionary decision from the court. It comes from the common law. Therefore, they will decide whether you fit or proper. The burden of proof will be on you, the applicant, to prove that you are fit and proper. What does it mean? It means you have to submit all your qualifications and testimonials that you are a good person. Now, in the past, this has been abused. And you need to know that, especially when the question counts 30. I want everything. So you will basically start on page 23 and say that it is a character screening, that you have to prove it. It is common law, but it is also in the different acts, or you can just say the Legal Practice Act. What is the reason? Why do you have to be a fit and proper person? That is on page 24. It is because you are entrusted with people, with their status, divorced or not divorced, with their money in your trust accounts. So you need to be a certain kind of person to do the job. You will find that on page 24. Your moral character is important. Then, if you go over to page 25, you have to give those examples. Do not elaborate, but give the examples how it has been misused in the past. For example, Wookie was not allowed because she was a woman. Gandhi was not allowed because he was of Indian background. Then Bram Fischer, and then Prince. You give me all of that, and you carry on and you carry on for the long question, the 30-mark question. You have to get to Mandela and Krauss and Matthews and Moseneke and Yassat. You have to refer to all of those in order for this overreaching 30-mark question. Or, I need not ask it that way. I can ask it differently. For example, on page 26, and you will see, nice question asked regularly, that the constitutionality of this test, of this fit and proper person test, has been tested twice. One time in the Constitutional Court on the interim constitution, and one time in the Constitutional Court based on the final constitution. You will see that on page 26. And you will have to discuss the Kleinhans case and the Mashaka case. If I ask you, has the fit and proper person test been tested constitutionally, yes or no, explain. Then you will have to say, yes, it happened in the Kleinhans case, it happened in the Mashaka case. But go to your study guide, find facts, 5 for the one, 5 for the other one. You cannot refer to the Rosamond case, because the Rosamond case was only dealt with in the Supreme Court of Appeal, not the Constitutional Court. But the Rosamond case can also be asked as a separate question for 5 marks. So make sure that you understand what happened in that case. That case was focused on the division between the role of an attorney and the role of an advocate. So make sure you are able to answer 5 marks on Kleinhans, 5 marks on Mashaka, and a possible separate question 5 marks on Rosamond. If I ask you what happened in Rosamond, you should know what happened there. Then if we go to page 28, this will still be part of the fit and proper person test, because there we indicate to you that in Krauss and Mandela, the character test was used. But then there was a shift. Our legal system then shifted to the duty test. And all the others were, they were either allowed or struck from the roll on the basis of the duty test. But be careful. If it's a 30-mark question on this whole thing of fit and proper, then you do not discuss Krauss in detail. You refer to it, but don't give all the detail. You refer to Mandela, but don't give all the detail. You refer to Matthews, not all the detail. You refer to Fisher. You refer to Hassim. You refer to Moseneke. You refer to Makubela. And then, of course, you end up with Prince. But I can also have another question. And you will see in last year's paper, I asked, compare Mandela and Moseneke. Then you briefly give me the facts of Mandela and briefly the facts of Moseneke, and then come to a conclusion in their comparison. Was different approaches used, yes or no? Moseneke is quite important because a lot of people get confused between Moseneke and Makubela. Make sure that you understand the difference. You need to know Moseneke. I mean, he used to be the Deputy Chief Justice. He's now retired. But know what he did, know what happened. It is quite important. Makubela, unfortunately, is not with us anymore, but also know what he did and what happened. And then Prince, remember I referred to Prince, postmodernism. Know what happened in Prince and be careful. You need to know whether the person applied to be admitted to do their articles or whether they were in practice already and were struck off the roll. So be careful, make sure you understand. Was Makubela already an attorney that did things wrong and therefore struck off the roll? Was Moseneke already an attorney, or was he a young man and he applied to be admitted? Same with Prince, same with Mandela. Make sure that you understand whether Mandela applied to be an attorney or an advocate. Some of you get confused and then you cannot get the marks. Make sure about these little detail, because that is where you get your marks. On page 35 at the bottom, I once again go back to the shopping list questions, and I can ask you, when is civil disobedience allowed? Under what circumstances will civil disobedience be allowed? Remember that you as an advocate or an attorney, you should not partake in civil disobedience, but you can advise your clients, and therefore you need to know when is civil disobedience acceptable or not, and you will find that in the bullets on page 35. Then if we go to page 36, the removal. Remember, the fit and proper person test is applicable when you apply to be admitted as an attorney or an advocate. So once you are admitted, now you do your job, but things can go wrong. Maybe you can take from the trust account, be bribed, whatever. And then we come to, how do we remove a lawyer who is not fit and proper anymore? And that is on page 37. In the case of Yassat, now this can also be asked as a separate question. You will see last year it was asked, what is this 3-stage inquiry that the court used in the Yassat case to determine whether this person should be struck off the roll or not? So make sure that you go and you see what the court said in Yassat. Then take note of Swanepoel and Mabaso on that pages, and the case of Geach, And now on page 38. You were a fit and proper person, you were admitted. You started your practice, things went wrong. You were removed. How can you get back, if ever, to go back to your profession? And that is the reinstatement of lawyers. And it is very important on page 39, the Kaplan case. What did the court say in the Kaplan case? How do they determine whether you should be readmitted? Very important to distinguish between the three requirements in Yassat and what happened in the Kaplan case. To be readmitted. Make sure that you know these things, and it can count 3 marks. You will see last year it was 3, but it counted 6, so every fact that you give was worth 2 marks. Okay, so then if we turn over, that was added to this learning unit. When we made this study guide, it was not law yet, but it is law now, the Legal Practice Act. And of course, because it's law now, I might test you to see whether you know that the Act exists and what is the purpose of the Act. You will see that it was asked last year. So it is on page 40. You will see the purpose of the Act is stated in section 3, and then it is A to G. Make sure that you know these things for a question of about 10 marks. Okay, and then you need to know that there is something like the council and that there is a new code of conduct. I indicate in your study guide that it is not in force yet. It is now in force, but you take note of it. I think the more important part is on page 42. What is expected of a legal practitioner? Once again, it's a shopping list kind of question. Page 42, you will see there are 10 dots. And I warn you again, because this is new, I want to know whether you are aware of it. So don't be surprised if you get a question eventually in the exam on either the purpose of the Act or what is expected of a legal professional, because that is what you are going to become, and that is what will be expected of you when you eventually enter the profession. Okay, this is the end of Learning Unit 3. You will have to click on the next YouTube video link for Learning Unit 4. Thank you.